Hello, data enthusiasts. Welcome to the Open Data Cafe, the podcast of DataEuropa.eu, the official portal for European data. In each episode, our fantastic guests will share insights and experiences on open data. Whether we're talking about how open data can foster transparency in government, kickstart innovative new businesses, enable powerful AIs, or empower citizens like you and me, we got it all covered. I'm your host, Gianfranco Cecconi. I've been knee-deep in the data sharing scene for quite some time, many of which contributing to DataEuropa.eu. Today I'm the Executive Director of the Data Spaces Support Center, yet another initiative dedicated to the implementation of the European data strategy. Our guest for today is Hans Groh, attorney at law and partner at Timelex, a law firm that, as part of the DataEuropa.eu team, has been advising the project since its start. With Hans, we learn about basic principles that we should all be comfortable with in the digital world, legal rights, licensing, and the liability when using data. And now, let's meet Hans. Good morning, Hans. How are you doing today?
Good morning. I'm doing excellent, thank you. Busy as always, but that's good.
Where do I find you?
Where are you?
I'm in Brussels right now, actually. Well, near Brussels, just outside of Brussels in the office.
And of course, we know each other. It's probably useful to highlight for our audience. We've been working together for 5 years as part of the team that runs and operates for the Publications Office of the European Union, data.europa.eu. And today I will take advantage of your kindness to talk about a topic that may look a bit alien to some, but actually, you know me well, I find it very, very interesting and intriguing. And I don't have a legal background at all. Though I love the philosophy of it and the thinking that goes into choosing the right words and the very interesting paradoxes created by mistakes sometimes when writing a license or a piece of legislation. And I love you to, let's say, enlighten us to all of this, but starting from the basics, because our audience should not be frightened. So for the ones listening at home, be patient, we will keep it simple and down to the point. But before we start, let's talk about you and your company, so we can then go into down to business.
Absolutely. So my name is Hans Groh. I'm a lawyer with a law firm called Timelex, established in Brussels. Timelex is a law firm that specializes in IT law, IT policy issues. We advise public and private sector clients on basically anything that involves digitization and modernization. So a lot of that involves, for instance, intellectual property rights, data protection, information security, artificial intelligence, all these kinds of hot topics, which makes it very interesting because indeed, as you said, a lot of this is about emerging policies, emerging choices, and trying to find approaches, legislation, and interpretations of the law that do good things for society in general. So it's a very interesting job.
And before we go down into regulation, I would start from the basics of what in the open data world is simply called licensing. A very misunderstood topic sometimes, and also in its relation with copyright. So without talking for the next 3 hours, because I know the two of us can do that, let's start from the first point. What is copyright?
So copyright is basically a legal mechanism, a legal paradigm that was created to protect creative work. The basic concept is that when you do something creative, when you do something, you make something new, that shows your personal creativity, your individual personal creative spark, that this is a work that belongs to you somehow. And the concept that was created for that was copyright, basically saying, well, you are the copyright owner, you are the author of that creative work. And then for a given period of time, people who want to use that work, who want to exploit it somehow, have to get your permission for that. So basically a mechanism that was intended fundamentally to encourage creativity. People sometimes forget that. The main goal of copyright is to encourage creativity, the creation of new and original works, with the idea that creativity benefits society as a whole. The more people create new paintings, new songs, new movies, the better off society is. And copyright is a mechanism of making sure that people are incentivized to do that, because some of the gains, some of the benefits of creating that work will end up with the author, the actual creator. That's it in a nutshell.
And it sounds to me like creative work is key there, right? So, and that reminds me of another right that is relevant and interesting on the side of this, that is database right. That's a bit more trickier to explain, perhaps? No.
Trickier?
Well, you tell me.
It's trickier also because copyright is pretty international. Originated, it's fair to say, in the Western world, but now is pretty much accepted as a paradigm internationally, as something that is, it exists in legal systems everywhere. Database rights are something uniquely European. The whole idea is indeed that some works are creative, like obviously the paintings, songs, and things like that. So it's clearly they're covered by copyright. For databases, it's a little bit trickier because some of them do require a lot of investment, a lot of time and efforts to establish them. But it's actually kind of hard to qualify them as creative works because, for instance, they might be just a large data set of objective facts, of objective data that, for instance, describes your environment, houses in your neighborhood, or the population in a given region, or measurements in scientific research. All of that is very important. It's valuable. A lot of investment was made, but actually it's not creative. The value doesn't derive from the fact that an author did something that really shows their personal creativity, but there was just a significant investment made. So copyright doesn't work there because you can't say this is really a very original work in the sense that it's indicative of human creativity. It's not an expression of your individuality, but it is valuable. And so in Europe, we have something separate that exists next to copyright, which is the database rights, which relates to those cases where a set of data has been created that did require a lot of investment, a significant amount of investment in time or in resources. And for that reason, you get a regime that sounds and looks very much like copyright, but actually is different on a couple of important details.
So let's say just the summary I use in my head is that copyright, creative work, as simple as that, although there are facets and complications related to it. And the other is database right is protecting the effort put in collecting data, not necessarily in creating or being innovative, but in the massive work I may have put, for example, to collect all addresses in my country, or all papers published by an author. That work in collecting fact is what the database right
exactly the lack of personal creativity. Basically, the idea, like, if somebody else would do exactly the same work with the same remit, they would wind up in the same place because there isn't that much margin for your personal individual expression. That's indeed the main difference.
Perfect. So we're building progressively on top of this. I like it. So now, when someone, say an institution in government or even a private individual, publishes a data set, he or she will probably have a combination of both. So I'm trying.
It's actually not to go too much into the detail.
No, but it is very important because this is the part where things get difficult and which will lead us naturally to licensing. The question is, if a government creates a data set, who is the copyright holder or who owns the database rights? So intuitively, you might say, well, in a lot of cases, probably there is no copyright because a lot of data there will be factual. And that's true for most of the open data sets. The information that you have in there is factual. It's descriptive. It's statistical data, neutral information. Usually, it's not protected by copyright. There can be exceptions. For instance, if a government would publish a database of, for instance, decisions that it's made in particular files, something that's really written out, authorizations, permits, arguably those are protected by copyright, but everybody will feel this is kind of a forced way of approaching it. If there's copyright, it's probably going to be only for a very small subset of data sets. And actually also, I think people sometimes overlook this, copyright actually doesn't even make sense in the governmental context. Because if you remember, the point of copyright was to encourage creativity, to encourage the making of new works. The government doesn't need copyrights as a way to incentivize them to do their work. It's just the natural part of the government's function. So copyright often doesn't apply. And even when it doesn't apply, just logically, it's a bad fit for that situation. So copyright is not very reliable. Then you say, well, okay, and thankfully we have solved this in the European Union because we have database rights. Clearly, often there is a significant investment, significant effort from the government in creating databases. But there's also a challenge there, a problem there, because there the question always is the investment that was made, the effort that was made. Was it actually done to create the data? or was the actual effort in doing your main job, governing, making sure that the government is running correctly? Because again, the point of database rights, that part was the same as with copyrights. Database rights exists to encourage people to invest in databases, to create data sets that we exploited. And we actually have rulings on the European Court of Justice saying, no, actually, this is indeed the heart of the matter. If you're creating a database because you want to exploit it, because that's an independent work, then database rights apply. But if the database actually kind of just originates as a side effect of your main job, then you're not investing in the database. That's not a significant investment, even though maybe you actually have to expend a lot of resources, a lot of time on setting up systems and paying people's wages to get that data. But that was not for an investment in the database. That's for your job, for governing. And again, also logically, the paradigm doesn't really fit very well, because governments don't need an incentive to create databases. They have a job to perform their public function, and databases just naturally originate as a side effect. So you wind up with a situation where actually copyrights aren't a very good fit and database rights aren't a very good fit. So where does that leave government data? That's the magical question.
I guess for simplicity, we can assume that whoever the data provider is, they have rights that ensure some kind of privilege for them. And if they want to enable others to reuse their data, they need an explicit way to tell them, you are allowed, I give you permission. Here, thereafter, you can use this data for some reason. And that's the license, right?
And that is the license. That's the heart of it. And this is why licenses are a good thing in the open data environment, and especially when talking about open government data, because these questions, when is copyright there, when does it exist, and when does database rights exist, and when should it exist, is complicated. It doesn't work. If you tell people who owns the copyright, I don't even know if there is copyright. Database rights, I don't really know. That's not conducive to a good environment. So in practice, even though you can argue about whether this is legally and policy-wise the optimal situation, in practice, people just said, look, we'll make it simple for you. Here's the license that says what you can do. This is a contractual document. You do not have to worry about that assessment about whether copyright works or whether database right works. Here's just a statement of what you can do. And if that statement, the license, is permissive and flexible enough, it doesn't even have to depend on whether there is any copyright or whether there is any database right. It just says, this is what you can do, here's your assurance, and now you can move ahead without worrying about whether copyright or database rights exist or should exist here.
That's a nice one. So I believe we have a very nice picture of copyright, database right, licensing now. And then I will make you a question where a lot of people fall, perhaps because it's not that black or white. That is, I found a website. There's a nice table with data published on that website. I probably can just copy and paste it. It is in the public, right?
It is not in the public. The fact that something is legally possible and that you can do this does not mean that you're allowed to do whatever you want. It can be the reality sometimes that people indeed say, look, this was on a public website, and if you didn't want me to use it, you should have protected it. You know, put it behind the login wall, whatever. But that's not how the law works. And this is the same thing as with sort of the more traditional creative works like music songs, videos that you have found online. It's not because you found it online that you can do what you want with it. You cannot assume that it's there with the permission of the rights holder, and you cannot assume, even if you know that it's there with the permission of the rights holder, that you can now do whatever you want with it. That is in the public domain. What you should be doing, and appreciating that not everybody does this, but what you should be doing is to check the conditions under which the work was made available to you. If you look at an open data portal, there a lot of work has been done, and people often don't appreciate how much effort this requires. A lot of work has been done to identify specific data sets, what the legal terms are, what the license is basically that you're expected to use. So say you want to get cadastre information about plots, areas of land in your area, you find a nice data set, and it will say, for instance, this is CC BY International. This is the basic attribution license, which, simplifying it a lot, basically means do what you want with it, but you have to credit the source in the way that they communicate. That is then the terms that you have to admit, that you have to respect. The fact that you could also just say, I'm downloading this and I'm doing whatever I want with it, does not mean that it's legal to do so. If you would do it anyway, you would be violating the licensing terms, and you could get sued, at the very least, for breaking that contract, maybe also for violations of copyright and database rights, but that depends on whether the claimed rights holder can indeed prove that they have copyrights or database rights, typically you would want to skip that step and say, look, I don't care if this is protected by copyrights or database rights. I gave you a license, it was published, it was made available under this license, and you broke the terms, you broke the contract.
Perfect. So without being melodramatic about it, copying a table of data from a website is like copying a film from a DVD or a piece of art. But, you know, for many, or at least it's common understanding that scraping data, that's the word that is often used, is acceptable or called fair use. What's that?
That is, so fair use, again, this is something from, it's a common law concept, continental European law, and this actually is a difference. So public domain as an expression has entered common usage, and that does work. If you say to European lawyer, this work is in the public domain, everybody will understand what you mean, and it has pretty much the same interpretation across the European Union. There are some minor nuances, but people will get it. Fair use, it's not the case at all. So fair use is a doctrine under common law, so in the UK and in the United States. It basically is a generic rule, a generic mechanism that says, even though I don't have permission from the rights holder, I consider my use of this particular work to be fair because, and then you have to explain why the use that you're making of this particular work is in line with what judges have said. Basically, it's more of a common law tradition where you have to look at case law, at prior decisions. Europe doesn't have that. Europe has a mechanism of legally defined exceptions. For instance, where I can say, well, you can use a work without permission of the rights holder if it's for educational purposes or for news gathering and news reporting. So there are some exceptions there, or for scientific, some cases for scientific analysis, but those exceptions are explicitly defined in the law. You could consider that to be the equivalent of fair use, but Europe does not have a generic fair use rule in the same way that the United States does. But so there are exceptions to that. And you do get discussions on that as well, specifically with screen scraping, because a lot of the internet in practice relies on automated screen scraping, automated processing. It's how search engine works. If you Google something, what happened is that Google scraped publicly accessible websites and structured the data, analyzed the data on it in order to create search results. And this is something that Google also has to be able to justify in the United States on the basis of fair use doctrine. In Europe, they would have to look at applicable exceptions under European legislation.
For the last question, I would go in a bit more complicated, even more complicated layer of what we discussed until now. So the copyright and the rights on the data, the licensing of the data and open data in particular, and something that perhaps we don't always think about, that is the liability. Now that data is used more and more, not just to generate insights, but to actually take decisions, say through artificial intelligence or other kind of algorithms and tools. What happens if I use some open data, probably published in the best faith, in best effort, and I take a wrong decision because the data was wrong or incomplete or whatever? How does liability works in this world that we've been talking about?
So the theoretical model would be that, the source, if their information is wrong and you rely on it, you could be held liable for it, but you can disclaim part of that liability through licensing. And as you've probably guessed, license terms always have very extensive liability clauses. Even in the simplest licenses that are, that are 10 lines long, which for a lawyer, that's magic to have a contract that's literally 10 lines long. I guarantee you, of those 10 lines, 5 of them will be a liability disclaimer that basically says, I'm offering this as is. And there's been a lot of interesting debates, especially in the early days of copyright, of open data, on whether this is compatible with European law, especially when your data is made available by consumers. Can you do that? Give people data and just basically say, it's whatever happens, it's not my problem. This is you have to do your homework. There's been a lot of discussions about that. Or about the responsibility of the state to put data out there, and then can a state do that? Simply say, this is data, and it might be terrible, but this is going to be your risk, your use case. I don't have anything to do with it. Can that happen? And the practical result is, yes, that seems to have been the reality, the practical outcome. I think I'm not aware of any cases, of any case laws where the court basically said, look, I know that you, government, said in your license I'm not responsible, but there was damage here anyway, so therefore I'm going to hold you liable. It will be possible to try that, but I haven't seen any cases where that happens. And also, I'm kind of happy that I don't know about cases where that has happened, because I feel, but this is an opinion, this is not a fact, that this is a reasonable outcome. Basically, the open data deal is basically saying, look, you make the data that you have available. You're not expected to be infallible. You're not expected to make extreme investments in ensuring superior quality or perfect quality of your data. What we're asking you is to share what you have and to make it available for reuse. And what the public gets is the ability to use the same kind of data that governments create and that they themselves rely on. And they have to make their own assessment on how far they want to go with that, how far their reliance has to go. But the deal is you're getting it for free. Well, in the sense that it was already paid by taxpayer money in this context. So relatively free, you don't have to pay anything additional on top of that. But it does mean that as a reuser, you have to make your own assessments on how far you can rely on it and what kind of responsibilities you choose to bear. But you cannot say, I took the government data and I was expecting it to be perfect, because that was never part of the arrangement. If you would want to do that, open data wouldn't work anymore. Then public administrations would always say, I can't share anything with you because my data isn't good enough. Nobody will ever say
they will stop publishing. Yeah,
they will stop publishing.
Yeah.
Yeah. So once again, the license is the savior of the reuser in a way. So we find a license, we ensure the license is authentic and it comes from the actual issuer, and we feel comfortable in a way. And if we use a standard license, we know that it will contain those liability terms, which infer that we need to be careful. We won't be able to go back to the provider to complain or consider them responsible for whatever we do with their data. I believe that picture is complete now. There's one last thing I want to ask you before letting you go. Sometimes, talking about how active the EU is in supporting its own data strategy and creating new regulation around data. If you are, I would think that if you're not a practitioner, you would feel possibly it's even too much, right? What is all this? Data Governance Act, Data Act, Open Data Directive, and so on. I personally think it is a good thing in a way. I mean, the analogy I usually make is a rally racing car with your partner telling you, oh, you're driving, your partner saying, oh, there's a bend to the left of this degree, and now you can go faster, as fast as this and that. Law is what enables me to go fast in a way, because I know exactly how the route looks like and what its risks are and what my boundaries are. Do you feel like that as well? In your experience, what would you use as an analogy to make people feel more comfortable and thankful in a way that we have legislation helping us?
So I think indeed, first of all, I think there's no way to deny that the legislation, the regulatory landscape is becoming very complicated. Data legislation in Europe, it's complicated because there's so much happening at the same time. So even if you're a practitioner, a specialist in this field, it's sometimes complicated to keep the full picture. Does that mean that I think legislation is going in the wrong direction? No, I do think that legislation is going in the wrong direction, because you don't even see a lot of discussion about the analysis of the problems that the EU makes on, for instance, allocating benefits fairly, making sure that you have competition, that you get innovation, and that people are protected against abuses that naturally originate when a very small group of companies are able to avail themselves of massive amounts of data. So the philosophy is not under dispute. The level of detail of the legislation is indeed very, very far-reaching. But it is important, I think, to get to a more competitive and a fairer landscape. And indeed, I think the analogy with cars is correct, or the analogy with airplanes is correct as well. You have very few airplane manufacturers because, for many reasons, because one of the reasons is that there's an extremely high technological barrier, but also there's an extremely high regulatory and compliance barrier. If you make parts for airplanes, if you assemble airplanes, if you sell airplanes, if you use airplanes, all of those parts of the chain are very highly regulated. And I absolutely appreciate that a lot of companies will look at that and say, look, I could never start an airplane production company, or I'd never even be able to start an airline because it's so heavily regulated and there's such a high cost of compliance. And the answer is yes, but that's good. If you don't have that, planes fall from the sky. bad for the pilots, bad for the people on board, but also very bad for the people on who the plane is going to land, who had nothing to do even with planes. It's just all of a sudden falling on their head. And the same thing is true for the data economy. Even if you say, look, I'm just a regular citizen. I'm not an IT company. I'm not even a user of an IT company. I'm not a modern company that wants to use data-driven analysis approaches in my business. No, you can just be a regular citizen, but the way data is used and exploited affects you in everyday life, even if you don't see it. And in the same way that you don't want to be walking across the street, minding your own business and having a plane falling on your head, in exactly the same way you want the data economy to be appropriately regulated. Is it going too far? I think we'll have to see. I think there's going to be an implementation and evaluation periods. I don't want to call it a regulatory standstill, but basically where we learn whether this is working appropriately. I'm sure some things will not work appropriately and they need to be fixed. But I'm actually pretty confident that the large lines, large principles are okay, and that this intervention was necessary to some extent. This is not a European analysis. All major economies are struggling with that question. Do you regulate the data economy? Do you regulate the data aspect of the data economy? And how far could you go? Are we early as a European Union? Maybe, but you can also spin that positively and say this is basically GDPR all over again. When the EU was also saying, no, you're too early and this is too burdensome and this is over-regulating. But a lot of what the GDPR did, not all of it, I do have some question and criticism, a lot of it worked very well. And a lot of member states will actually say, well, the EU with the GDPR set a gold standard. Not because it's perfect. GDPR is a flawed instrument in many ways, but the net effect was quite positive, even to the point that a lot of non-European jurisdictions say, we should have something like this. Maybe improve it slightly, but like this. And I can see the same thing happening with data legislation as well.
So thank you, Europe, for legislation, and thank you, Hans, for being with us today. Good luck with the future work, and yeah, catch you up soon again.
Absolutely. Looking forward to it. Thank you very much.